Joining me now, Diana Florence, a former prosecutor for the Manhattan District Attorney's Office, and SARA AZARI, criminal defense attorney and NewsNation legal contributor. Thank you both for coming on the program. Appreciate it. All right, Diana, let me start with you. How do you think so far that Carol's case is going? Case is now in. The closing arguments are now in. No defense presented by Trump's team. How well has she done?
I think it's gone about as well as it possibly could for the plaintiff. I mean, I think the fact that there was no defense at all, in order to find for the defense, you have to literally think that 11 different witnesses joined together in a conspiracy, and that's just not credible.
And the bigger problem, I think, Sarah, is even if you take out all the 11 witnesses, there are these two witnesses who testified in this case, both of whom say that she told them about it at the time, this woman Carol Martin being one of them. You kind of have to believe all three are lying, right?
Right, and outcry witnesses are very important. That's what you're referring to, is that very close in time to the incident, the victim of abuse actually made the disclosure. Because one of the things defense attorneys do is say, "Oh, why did you wait? Why did you wait so long?" Well, she didn't. She actually mentioned it. I think she was confused about whether it was an assault, but definitely stated the facts in a way that these women believe.
But Tacopina is saying that they're all lying, all three of them. He's basically saying this was political, that all three of them were in this together, and that's why he used that quote that I just mentioned up there, which he was suggesting was an effort to concoct a story, right?
You know, I'll tell you something. I was disappointed with the defense. I think that Carol had very defensible claims, both in terms of defamation and the rape. Obviously, part of it was because Trump boxed himself in by this flat-out denial. You couldn't say there was consent. You know, this lingerie thing in the dressing room, part of it was consensual, admittedly, and then he crossed the line. So they couldn't argue consent. They couldn't argue alibi. The look-back window law that passed in November 2022 really is a disadvantage to the accused, because they cannot, it's plain and simple, he said, she said, they cannot get documents or witnesses 30 years later to defend themselves, and the statute of limitations is no longer a bar. The issue here is they should have at least put on a case. They should have had, much like in the Cosby case, in the civil part, which happened in Los Angeles, they had the victim or alleged victim examined by a forensic psychologist. They didn't even do that. So as a lawyer, as a defense lawyer, I can argue whatever the hell I want, but where's the evidence to back it up?
But Diana, I think that the strongest arguments for Donald Trump's team, right, are the ones that we hear from lawyers a lot, which is they still have to prove the case. Yes, it's a lower burden in a civil case. It's not proof beyond a reasonable doubt.
Right.
Just more likely than not, preponderance of the evidence.
Right.
But still, she has the burden to prove the case. And what Tacopina did in a number of instances, for example, this is number 24, he talked about her liking the show The Apprentice. She said, "I was a big fan of the show, very impressed by it. I'd never seen such a witty competition on TV, and it was about something worthwhile, competing." And she went on to make a joke on Facebook about having sex with Donald Trump in 2012, where she said, "Would you have sex with Donald Trump for $17,000, even if you could, A, give the money to charity, B, close your eyes, and he's not allowed to speak?" And he then said, "So you joked around about it, etc." I mean, these are the sorts of things that her team is saying, we can explain it, etc. But if not all the jurors come to agree with her case, it's going to be things like that.
Sure, but I mean, what Tacopina is doing, and fairly skillfully, is stringing together, this is a pearl necklace of reasonable doubt, or sort of doubt about the case, right? Even that email that you cited in your opening remarks about Carol Martin saying this hasn't happened yet, and Tacopina, I believe, highlighted that in his summation. What's interesting about that is anyone who's paying attention knows that it's not hasn't. Hasn't is a present tense. It's not hadn't. In other words, it's very clear in the context of what that email was.
Hang on, but let's talk about the Facebook. I mean, the email is something else. The Facebook post and her being a fan of The Apprentice, right? Those are things jurors can understand, right? It's not burdens. It's not legalese. It's just saying, wait, this guy raped you and you went and liked his TV show and you talked on Facebook, you joked about having sex with him.
Right, but jurors also have common sense, and jurors also understand that people process trauma in different ways. And in fact, I think that when you're dissecting that evidence in the jury room, you're thinking about, why would she come forward? Why would she put herself through what we know the Trump machine is capable of doing?
See, I think that's an easier response than the evidence itself.
Yeah, and also processing trauma. You know, I think the one good point the defense made is you don't even remember the date. I mean, this is Donald Trump assaulting you in this department store in this outlandish way. It's not like you're a child who's, you know, molested by an adult. You block it out of your memory. You've talked about it. You've told your friends about it. You actually went into the dressing room to try on lingerie. This is not, you know, some drug date rape kind of situation that you're so traumatized over that is blocked out. So those are really good points that, again, I think he could have had a consent defense, but he really messed that up for himself, and I think his defense lawyers also did an inadequate job.
Well, I mean, it's not a consent defense because he's saying it never happened.
That's what I'm saying.
I mean,
by doing that,
you're asking him to make up facts. He's saying it didn't happen.
That's what I'm saying.
He's saying it didn't happen, then you don't have a choice.
Right.
And the problem is that politically and for whatever other reason, he's decided he can't have a consent defense here. I mean, look, he has claimed that this never happened. And I think that, I have to tell you, I think that that picture, and let's just show this as we take a quick break here, because we're going to come back with this in a minute. This is the picture that they were talking about with Donald Trump, and we don't have the picture. Oh, there it is. So that's her on the left. She does look like Marla Maples.
Sure.
On the left. And Donald Trump is saying, look, she's not my type. She never would have been my type. That picture may be the single biggest problem for Donald Trump. I've laid out all of the problems for Jean Carroll's case. This picture may be the biggest problem for Donald Trump's case, considering what we heard in that deposition. I'm going to ask you guys to stick around because we're going to play more of Donald Trump's deposition. Because I want to bring back in Diana Florence, a former prosecutor, and SARA AZARI. So the requirement of being unanimous here, that could lead to a hung jury, right?
Sure.
I mean, that could create a situation where you have 7 or 8 who say, yeah, yeah, and it's a Manhattan jury, too,
Yes.
which I think helps E. Jean Carroll a lot, right?
I think it does.
Yeah. I mean, it's not the jury that Donald Trump wants.
No,
Yeah.
definitely not.
Manhattan juries are very sophisticated.
And they're also liberal.
Yeah.
I'm just saying, like, they're both, right? But in terms of a jury that Donald Trump wants, this is not the jury that he wants. I don't think, unless.
No.
Yeah. Okay.
I agree.
All right. Let me play. Another piece of sound. This is from more of the deposition, which is just fascinating stuff. This was an interesting interchange where Trump's lawyer was trying to show sort of his hypocrisy, and then made it kind of a political debate about mail-in ballots, et cetera. This is number 12. Let's listen.
This ridiculous situation that we're doing right now. It's a big fat hoax. She's a liar and she's a sick person, in my opinion, really sick. Something wrong with her.
Okay. In addition to the Russia hoax, the Ukraine hoax, the Mueller hoax, the lying to FISA hoax, the lying to Congress hoax, and the spying on your campaign hoax, isn't it true that you also referred to the use of mail-in ballots as a hoax?
Yeah, I do. Sure. I do. I think they're very dishonest. Mail-in ballots, very dishonest.
And isn't it true that you yourself have voted by mail?
I do. I do. Sometimes I do, but I don't know what happens to it once you give it. I have no idea.
Didn't seem to me like this was a particularly effective line of questioning. I mean, she's trying to show that he's a hypocrite, right?
Right.
But
I actually think it helps the defense, and the defense didn't really argue it. What I would argue is this is just opinion. You know, when he calls all these different things hoaxes, it's just the guy doesn't like to be investigated for anything, and he's just calling it a hoax. It's not that he's stating a fact and saying it's in fact a hoax, calling her a liar, which then would be defamatory.
how much is politics going to come into the deliberation process? I mean, the defense has made this very much about politics, saying that Lisa Birnbach, who was one of the corroborating witnesses,
Sure.
was, a Democrat, that E. Jean Carroll is a Democrat. How much do you think politics is going to come into the deliberative process?
Well, I think that they were voir dired very clearly about politics, and they're supposed to put their politics aside and their biases. They're supposed to base their verdict on the evidence. So I don't think that it's going to be, Republicans on this side, Democrats on the other, such that there are in Manhattan. Or even, I think that this jury, I do have faith in the jury system. They're going to look at the evidence, and they are going to hold them to their burden. Unfortunately for Mr. Trump, I think that they've met it.
Yeah, and again, I find that jurors don't get enough credit a lot of the time from people not watching. They say, oh, the jurors are either going to be biased, or they're going to be dumb, or they're going to be this. The vast majority of times, you go and you talk to the jurors after the fact, and they say,
yeah.
Things like, wow, they really understood the nuances of this case.
Yeah.
So I say that before there's a verdict. So when people start yelling and screaming about the verdict, this and this, I'm going to probably say the same thing no matter what the verdict is.
But, Dan, I think also what helped Carol is some of the evidentiary rulings, like the admission of the
and so there could be an appeal. There could be an appeal, even if Trump loses, he could absolutely appeal, saying these other witnesses who said that he attacked
should not have been allowed to testify.
And that's a real issue.
Right,
That's
and also the Access Hollywood tape, that is evidence of misogyny. That is not evidence of
they said it was
him being a rapist.
Well, they said it was evidence to show this was his MO. Right. This is
but I mean, he's saying disparaging things about women. That doesn't mean he goes around raping women. It's disgusting, though, and it's prejudicial. Before a jury.
Well, you also saw the judge complimenting Tacopina multiple times in evidentiary hearings during the trial. I think that's setting up the idea that there might be an appeal.
Yeah, I think that. Well, I think if Trump loses, we know there will be an appeal.
Yes.
SARA AZARI, Diana Florence, and Adam Classwell. Thank you so much. Appreciate it. Coming up.